hi again, everyone. It's Merideth Nagel here, and I'm coming to you the first week of November 2021. You see a beautiful fire in the fireplace. There's a chill in the air. And what's really exciting, you know, I'm a nerd, I get excited about this stuff, is this is the first week of the new FARBAR standard and FARBAR as-is contracts that were amended to be effective November 1st, 2021. Now, you're going to need to talk to your broker. I always ask you to defer to your broker, but it is my advice that you need to use these versions of the contract. They're much improved. And in my opinion, you're probably not following your ethical obligations if you're not using these contracts. Now, before we get started, I do want to remind you of a couple things. First of all, you have, as a listing agent, the absolute right to insist that certain offers be made on certain documents. So you can put in your realtor remarks that all offers must come through on an as-is 2021, or my preference, the standard 2021. And I've got videos that discuss the differences between the standard and the as-is and why the standard is usually better for your sellers. So you can require in your realtor remarks that your buyer agents use these new versions. Of course, they can disregard your instructions and submit any contract they want, and then you'll have to talk that through with your lister. It's my very good advice that you need to be using these contracts going forward. Now, we're going to cover the kind of major highlights. I am not going to bore you with details that I don't think are going to impact your day-to-day practice. However, if you ever have any questions about anything I'm discussing or anything about the new contracts that I am not discussing and you want to talk about, please call me. I'm going to give you my number at the end of the video. I will be very glad to answer your questions and help you in any way possible become the best in the business. That's my goal, to make sure that you are have a successful, knowledgeable practice of your real estate. So without further ado, let us begin. Starting at the beginning. Now, we're not going to go through in the order of importance. We're going to go top to bottom in the contract. So let's first start at the personal property conveyance section. On the first page of your contract, you have that section where you're very familiar with it, where it says things like the dishwasher is conveyed unless you scratch through it. Well, in recent years, we have been having problems with some of the new technology, and we've addressed those problems in this version of the contract. So, for example, the new version now requires that TV wall mounts and hardware be conveyed unless you scratch that through in the contract. So we're not going to have any more last minute at closing, everybody freaking out because the TV hardware has been removed and now there's holes in the drywall. That TV mounting hardware is to be conveyed unless you scratch it through. Similarly, some of the high-priced thermostats now, everybody's got a smart thermostat, a smart doorbell, those kinds of items also are going to be conveyed unless you scratch them through. Make sure you pay attention to that, because I'm finding that some sellers are really married to the $300 doorbell that they have and they really don't want to convey it. So pay attention to that. Also, if there are keys that should be conveyed, it now says specifically they must be conveyed. And here's where this can kind of bite you if you're not prepared. As y'all know, some of our homeowners associations have a separate key for their facilities or for their mailboxes, and those replacement keys can be very expensive. And some of your sellers don't use those and they don't have them on hand. For example, they get mail somewhere else, or they don't often take advantage of the pool, and so they might not be able to locate those keys. Well, if you don't scratch those out in the contract, they're going to have to pay for replacements to convey at closing, and that can be expensive. So pay attention to the new personal property section. Some of you guys remember back in the oldie days, some of us, we've been doing this a long time, we remember when you went to a closing, what your seller got at closing was a check from the attorney's office or the title company, and then they would take that check and they would deposit it into their account, and they would wait the required numbers of days for that check to clear for them to have their funds available. That worked. Nobody really questioned it. However, we are now in the age of the wire. Now, I have a separate video on the dangers of the wire and why I suggest that you not have your seller proceeds wired unless there's a reason to. But assuming that there are going to be wires in the transaction, what we see sometimes, and we've been having this recently, I'd say in the past year and a half, A seller refusing to release keys and consider the deal closed until the wire was in their account. In other words, a seller would demand, I'm not closing because I don't have the $250,000 wired in my account right now. Now, it's always been the rule that when the closing agent gets the money, the deal is closed. But what's happened in this new revision is we've just made that very clear. So there's going to be no more last minute arguments about a seller refusing to release keys because they don't have the money in their account now. It's very clear that when the money hits my account as the attorney or the closing agent, the deal is done. Maybe the seller will get their wire that day, depending on the time of day they close, but maybe they won't get the wire till the next day. In any event, the deal is closed when the money is in my account. So hopefully that'll clear up some kind of last minute problems that we've been seeing. I want to talk briefly about this section in the contract. It's been there ever since we went through the TRID changes, remember those years ago, and the creation of the famous CFPB. And you'll remember that we had a new HUD, which we now call a closing statement, a closing disclosures. You remember all those things changed. Well, when the government rules changed and they required that a party receive the closing statement within a certain number of days in closing, what would often happen is that we couldn't meet those deadlines. We being the lenders couldn't meet those deadlines because there might be a last minute change. And so they would need an extension of the closing date just for the purpose of this renotice, right? So the closing disclosure needed to be amended because there was a last minute change. The rules required that they couldn't close within 3 days of the new closing disclosure being issued. So there was an extension, an automatic extension provided for in the prior version of the contract. Well, it really wasn't as clear as it is now what those extensions were to be allowed for. And so I have seen buyers agents trying to use that CFPB extension as a general loan extension, right? So they're almost at the day of closing. The loan's not final and approved, and they want to rely on this CFPB provision because, of course, that meant that the lender couldn't get the disclosure out within the time required by the closing date. Well, that's not what that extension was ever intended for, and so now we've tightened that up. So the only time that a buyer can use a CFPB extension, it now says the loan has to be approved out of underwriting, the loan is done, and it really is just for that notice requirement, and that time has been shortened to 7 days. So hopefully that'll help clear up any confusion and, again, kind of last minute wrangling. A lot of you guys end up in circumstances where you have to use a pre or post closing occupancy agreement. When you see those, number one, almost every lawyer you talk to is going to tell you they don't like those agreements. It causes a lot of problem if the deal falls through, but sometimes you just don't have any choice. Well, the old version required that the parties enter into a lease prior to closing in order for these pre or post-closing occupancy terms to be enforceable. Well, we don't like that, especially us lawyers don't like that. We don't like a lease because sometimes that imposes obligations on the seller or gives rights to the buyer that nobody really intended. And you actually had some funky situations where post-closing people were having to go through an eviction proceeding because they were considered under the law to be tenants, which is a terrible result. So now what we've made clear is that you only need to have a pre or post-closing occupancy agreement. And if those agreements are not negotiated to terms that are happy for everyone, then the extension, the pre and post closing writers now provide a right of cancellation if those agreements can't be reached. So again, I have another video about the importance of not writing your own agreements. You're not allowed to write these, guys. That would be the unlicensed practice of law. So make sure that you're getting, I know that for a lot of brokerages I work with, I have drafted these agreements for them and they use them in their transactions. I'd be very glad to do that for you, as a lawyer who's allowed to do it. So reach out to me if you need these agreements in place. But at least now the new revision makes clear that they're just agreements and not written leases. So next we have the financing contingency. Now this is the one I'm really excited about. You guys, if you watch me enough, you know I get excited about almost everything, but this I'm really excited about. We have been mucking around with the financing contingency language for years, and it seems like it has been getting more confusing and not less. So I'm hopeful this go round, I really believe this go round, it's a lot better. So again, some of us have been doing this for a long time. We remember the days when you could cancel, a buyer could cancel the contract all the way to the day of closing and get their money back if their loan fell through. And there used to be like a little cottage industry, I'm sad to say, of lenders who would write these denial letters on behalf of their borrowers who really kind of had been approved, but just didn't want to close on the house anymore. So in any event, what we've done now, we tried to tighten up for that. We made it clear that there was a time in which the deposit became non-refundable, but it was still confusing and mucky. So here's what we've done. We've simplified the situation. This is going to put a burden on lenders and buyers, so pay attention. Number one, the loan approval period, which is provided for in the contract, and it is 30 days, just like it was before, unless you write in a longer period of time. The loan approval has to be issued within that time, but it has to now include appraisal. So it used to be under the last version of the contract, if loan approval was issued, the closing could still be contingent on appraisal. So we would have really kind of nobody in the transaction being sure whether it was going to go through, even with a good buyer who had been approved, because we were worried about appraisal. And that was happening right up until the closing date sometimes. So what we've done now is we've made it clear that those appraisals or alternate valuation that the lender needs to use have to be undertaken during the loan approval period. So let that sink in for just a minute. So the lender is required not only to get the loan underwritten and approval issued as to the specific buyer, now the appraisal and the valuation has to be determined during that same period of time. So this is going to be a lot better for the parties because they're going to have more confidence in the finality that this thing's actually going to close a lot sooner. But then, of course, it puts a burden on the lenders and the buyers to get these appraisals done early and paid for much earlier in the transaction. So now, under the new loan approval language, the only way that the buyer gets their deposit back after that loan approval period, the only way they get their deposit back is if the seller defaults or if there is a property-related condition. So, for example, it's just discovered at the walkthrough that the air conditioner is no longer working. That, the lender's not going to loan money without a working AC. So that would be a property-related condition, as an example. So this is going to give us a lot more finality a lot earlier in the process, but it does put a big burden on your buyer to get those things paid for, and the lenders and the title companies and the appraisers to get those appraisals done earlier. And a lot of us are aware it's taken a long time to get appraisals back. So as you're working with, if you're a buyer's agent, be in touch with the lender and be realistic about the time that they're really going to need to get this all done so that we can set expectations early in the process. So just be aware of that. A little more about the financing contingency. So as I've discussed with you guys before, and I'm like a broken record. I have a video of this in the Homeschool for Realtors page if you want to go back and look at that. But as I've explained to you guys before, the loan approval period at the end of that 30 days or whatever the buyer has written into the contract, at the end of that time, if loan approval has not been issued, and I mean a loan approval, a pre-qualification letter is not loan approval. A letter that says, yes, we approve this loan so long as boom, 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 that's not loan approval. Loan approval is a commitment from the lender to close the deal. If loan approval is not obtained within the time allowed by the contract, then the buyer has two options. They can cancel the contract and get their deposit back, or they can move forward without the loan approval. But if they do that, their deposit is at risk. So they have to decide by the end of the loan approval period, if they haven't gotten that loan approval, are they going to take a risk on themselves? Are they believing their lender as to the status of their loan? Or are they going to cancel and protect their deposits? So it's always been important to work with a local lender that you trust and that you know can get deals done. But it's even more important now because our local lenders are going to be aware of and pay attention to and care about this Florida change. And it's important. The other thing that the new contract does in regards to this is it makes it very clear that the parties are able to get updates from the lender as to the status of the loan. Now, that's always been the case, but it's even more clear now. And I really want you guys that have not been taking advantage of this, buyer's agents and seller's agents, be in contact with the lender and find out the status, because this is a big risk. Remember, we said the buyer has two options. If they don't get their loan approval, they can move forward at their peril, meaning that if it eventually the financing falls apart, they don't get their money back, or they can cancel. Well, the seller has an option too. The seller, once they're notified that the loan is not approved by the end of the loan approval period, they have to hear from the buyer either, here's my loan approval, or I haven't gotten the loan approval. Then the seller has 3 days to decide whether the seller wants to move forward at their peril, meaning they realize that it may be that they get to the closing table, the deal's not going to close, and the best thing they'll have is the buyer's deposit, which is sometimes woefully too small, which is a whole nother subject we can talk about in another video. But in any event, so the seller has an option now. The seller can cancel within 3 days of learning that the loan approval hasn't been obtained. Now, if the seller does cancel under the circumstances, the buyer does get his deposit back. So again, it's going to be important that you're talking to the lender on both sides of the transaction, for the seller to know and for the buyer to know. Is loan approval not issued because it's a small, tiny little problem? For example, I had a file once where a loan was delayed because the lender wanted a photocopy of an actual college graduation certificate, diploma. It wasn't good enough that those transcripts were submitted. I mean, who knows? So if you're finding out when you're talking with your lender it's some minor thing, well, then maybe the parties want to go ahead and feel pretty good that it's going to close. If what you're hearing when you're talking to the lender is that they can't get pay stubs to match what the buyer put in on their application, then that might be a deal that you want to advise your seller to walk away from. But again, separate yourself as the professional with knowledge that you are in communication with the buyer's lender, and you can talk to your lister about what's happening with the loan. Now, there's a lot of focus on protecting the sellers in this situation. You know, is the seller going to really be able to close? I think we can't forget that we also need to be protecting our buyer's agents, because there's nothing more heartbreaking than a buyer who has, got their heart set. This is the home of their dreams, and they find out the day of closing that the deal's not going to fall through. I mean, the deal's not going to close. I mean, that's heartbreaking. Not only have they spent a lot of money to move and all of that, but they've got their heart set on a place. And so let's help our people. Let's stay in contact with the lender and find out what the real status of the loan approval is. Next, we're going to talk about surveys. A little known fact is surveys were actually supposed to be obtained much earlier in the process. The new contract change makes it clear that the survey has to be obtained 5 days before closing. If your buyer needs to cancel on a survey issue, they're not going to be able to do that if they don't get their survey until the day of closing. The survey has to be completed and evaluated, and if a survey objection is going to be raised, that has to happen no later than 5 days prior to closing. Now, I'm going to tell y'all what you already know, and that is we are having a hard time getting surveys. Frequently, we don't get a survey until the very day of closing. That's a problem, right? Most realtors, in my experience, don't take the time to really think about the importance of the survey in a transaction. So I'm going to take this opportunity to give a little preaching. Back in the oldie days, almost every lender required a new survey as part of a loan transaction. They required that survey be done, it be certified to the lender and certified to the buyer. That certification, that means in the name of the buyer, is super important, because if a survey is not certified to you, then you can't sue somebody if they've made a mistake, right? So the lenders used to require that, and it was really smart. It was really smart. It was a good thing for the buyers and a good thing for the lenders. However, Once one lender eases up on something that releases an expense, of course, then all have to follow. So now almost every lender will allow a buyer to rely on what we call in the industry a prior survey. In other words, you can get a survey from the seller, and if that survey looks okay, the lender will accept it. Now, a lot of buyer's agents have liked this change because in their mind, they've just saved their buyer between $275 and $500, or maybe even more if it's acreage. They've just saved money for their buyer, but they're not thinking it through. And here's why. One of the reasons that the lenders can be so sanguine, care less about whether there's a new survey or not, is hardly any loans fall through because of a survey issue. So think about it. What the lender is concerned with is not how the buyer can enjoy their property, what they can do with their property. What the lender's concerned with is whether their loan's going to be paid, right? So if your buyer encounters a problem with their property later that could have been resolved by an earlier survey, the bank doesn't care because hardly any buyer walks away from a loan obligation because there's a survey problem. But their enjoyment of the property can be drastically changed by problems with the prior survey that could have been resolved and found out about and addressed earlier if the agent had recommended and if the buyer had in fact obtained a survey. So let me say this again, and I'm going to try to say it shorter. The survey protects your buyer. It protects them from unexpected things. For example, if they rely on a prior survey and they think they can put a pool in their backyard, and it turns out that the prior surveyor located the property 2.5 feet in the wrong direction, or maybe even inches in the wrong direction, now your buyer can't put a pool in, and they could have found that out if they had had their own survey done, and there's nobody for them to sue because the survey wasn't certified to them. It wasn't made for them. So they can't turn around and sue that prior survey because he made a mistake. If it had been made in a survey certified to him, he would have that protection. So I frequently hear realtors ask me questions like, well, why does my buyer need a new survey in a subdivision, right? It's lot 42, Oaks of whatever. Why do we need a survey? Let me give you this. I have so many stories I could tell you, but this is the one that I like to use to explain how you probably should always have a survey. I had a client come to me after they purchased a property. Their realtor advised them they didn't need a survey because it was in a townhome community. So the realtor thought, nah, you don't need a survey. It's a townhome. What could be the problem? So the buyer didn't get a survey. She was a cash buyer, so the lender didn't even require a prior survey. So she enjoys her townhome, and then she goes to move, and her buyer that is buying from her smartly gets the advice that he should have a survey. He gets the survey done, and what does it reveal? There is an easement running right down the middle of the townhome. It was a mistake that was made during the platting process, and it made that property virtually unsellable because that was a problem that the lender would not agree to make a loan on. So she had to spend almost $30,000 in attorney's fees to get this easement removed. And if she had spent $325 on her survey at the time of when she bought, she wouldn't have had a $30,000 problem. Surveys are kind of like insurance. There's hardly ever an issue, but when there is an issue, it can be a really big one. And who do you think that buyer blamed for the fact that she didn't get a survey? She blamed her agent on that side of the transaction. You guys already know. I don't have to tell you. If something goes wrong in a transaction, whether it's your fault or not, you're going to be blamed. Next, we're going to talk about the force majeure clause. And some of you are like, what? Force majeure? What is that? Well, that is a fancy legal term for an act of God. And that has always been a part of our contract, and it's mostly never paid much attention to. In fact, I have a lot of questions from realtors that don't even realize that this provision is in the contract. So let's talk about it, and then let's talk about what the changes are. So there's always been a force majeure provision, which provides if there is some act of God that prevents closing, then the parties are entitled to an automatic extension. So for example, if there is a hurricane coming and your buyer cannot close on their loan because they cannot obtain home insurance until that hurricane has cleared out. You don't need an extension for that purpose. Don't draft extensions you don't need. It's already covered in your contract. There is a force majeure, which is the hurricane, the act of God. And if that prevents people from being able to close, then an automatic extension is already in place. Seller doesn't have to agree with it. It's already in the contract. Well, what we've done on the revisions this time around is we have expanded and a little bit, I hope, clarified what kind of things count as an act of God and how we handle it if there is one. So, because of COVID, believe it or not, there was a lot of legal ink spilled on whether a global pandemic qualified as an act of God. So during the worst times of COVID, we had people trying to figure out, well, the title company is closed. Can I get my deposit back? What do we do? And there was actually some opinions issued by lawyers a lot smarter than me and judges way smarter than me that said, it's not listed as an act of God example in the contract, so it's not an act of God. That's kind of counterintuitive, but so we address that by making it clear now that epidemics, pandemics, civil unrest, you remember some of the problems that we had with whole streets and downtown centers having to close because of protests during the summer. Those kind of things, the contract makes it clear now are covered as acts of God. The act of God begins when the incident begins. So like using our hurricane as an example, when the hurricane police, whose name I don't know, National Hurricane Association, whatever that is, when the hurricane police say we are now under hurricane warning, whatever day that happens, that's the start of the act of God. And then you have an automatic extension 7 days after the act of God ends, right? So if we're put in hurricane warning area on Monday, even if the storm comes through and the skies are beautiful on Wednesday, if that hurricane warning has not been ended or removed, then you're still in that act of God period. So the time, this automatic 7 days extension begins when the act of God is done. So again, in our hurricane situation, it's when we're no longer in hurricane territory. Now there is 7 days to close. So hopefully this will make it a little easier for you guys. I pray to God that, of course, we never have another epidemic or pandemic, but it's a little tighter and easier to understand now in something that we frequently have in Florida, which is hurricane season. So hopefully that change will help you. There's also been a change in the way that time is calculated. So you will remember that back in the most recent version of the contract, time was calculated. Some days you used the whole day, and for some periods it was time ended at 5 o'clock. Well, we've changed that. So if you have a 7-day period, 5-day period, 30-day period, whatever your days are, those days end at 11:59 when the day ends. So you have all in the evening, all the way up to midnight is your day. So that's an important change. So now you don't have to worry about, wait, am I a 5 o'clock day or am I 11:59 day? It's all 11:59. So that's a good, important change. Also, for those of you that sell property in parts of Florida that are located in the central time zone, the contract now makes clear that computations are based on where the property is located. So whatever time it's 11:59, where the property is located is when the day ends. If you have a situation where a holiday is celebrated on a different day than it actually occurs, and when I say celebrated, of course, I mean businesses are closed, you use the day that the business is closed. So in my situation, even though the legal holiday fell on a Saturday, if the banks and businesses are closed on Monday, then it's going to be Tuesday. Now, we've always kind of understood that to be the case, so this shouldn't be a big change for you guys, but hopefully what we've done is just made that a little clearer. So I think those time computation changes are going to be helpful. Next, we have another favorite topic of mine, which is what kind of notice is sufficient notice. Now, I know that a lot of you guys love to practice your profession via text message. I get that. Trust me. I much prefer text messages. In fact, sometimes I get annoyed when little truth confessions. Sometimes I get a little annoyed by phone calls. I'm just like, just text me. I don't have time for a conversation. So I understand it is an integral part of how you guys need to do your business. However, we have made it clear now that text messages are not binding on anyone. Doesn't mean you can't use them. You can still reach agreements via text, but to make those binding, you now have to, what's clear is you now need an email. So we've made it clear you can't use a text, but we've also made it clear that an email is sufficient. So I need you guys, when you reach agreements with agents or even with your own client via text, wonderful, but then go back to your computer as we confirmed via text, and send the email, and that way you have email notice. We made that change in large part because text messages kind of go away a lot easier than emails do. And I think there can be lots of misunderstanding in text messages. So hopefully you'll find this to be a good change. Whether you like it or not, at least now you have a rule. You can conduct your business by text, but make sure that you confirm everything with an email, because that's the only notice that is now sufficient under our new contracts. Finally, the contingency writer. We've got a lot of great, and I'm not really touching on those right now. There are a lot of great improvements in our writers, and I want to take an opportunity to pitch the importance of using your writers. I see lots and lots of agents writing in on the additional terms section of their contract, subject to the sale of buyer's home at 123 Main Street. Don't do that. Number one, you're not supposed to be doing that because that's the unlicensed practice of law of you're writing a contingency that you're not supposed to be writing. That's the unlicensed practice of law. But most importantly, you've really hurt the parties by doing that, because we have these well thought through writers that give obligations and rights to the parties, but on both sides, that make a lot of sense in the transaction. The contingency writer is just one example. So instead of just writing in sale contingent on buyer's sale of 123 Main Street, if you use the contingency writer, it has some great things in it. For example, the buyer has to give you a copy of their contract when they make their offer, and they say, well, we're selling 123 Main Street, but it's supposed to close, on November 15th, so we should be fine. Now they are required within 24 hours of their offer, not the acceptance of the offer, the actual offer, to give a copy of that contract. Now, the identifying information, the confidential information, has to be redacted out, use a Sharpie, but those contracts have to be submitted. And that will help you, because sometimes when you actually look at the contract, you'll see that buyer had a contingency on their own sale. And so now it's really starting to get concerning whether this transaction is really going to close. So use the contingency writer. So we've made it clear that the offers have to be presented, and there's other time frames within the contingency writer that you need to be paying attention to. We've made a lot of changes to writers in general. I want you to take a look at those. I want you to take a look at the changes in the VA, the FHA, the energy efficiency. There's been several that have been changed. Please pay attention to writers. Use writers in your contracts. We've made an important change in the HOA rider and made additional obligations there. Take a look at those for purposes of brevity. I'm not going to go over those now, but we are going to have a separate class later on how you handle, under the new contracts, special assessments issued by a homeowners association versus special assessments issued by a governmental entity. So take a look at those riders, use them, understand them. I hope this has been helpful to you. If you would like something that I have that I think is gold, which is what we call in the legal world a marked up copy of the old contract, which just means you can see on a document what has been added, what has been deleted. If you want one of those to use as a handy reference, please give us a call at the office. I can always be reached at 352-394-7408. Call the office and ask to speak to Eliana. She will send you a copy of that as well as a copy of all the amended writers so that you can have those handy. You don't have to close with me to get this information. I'm so glad to provide it to everyone. Similarly, I am so glad to answer any questions you might have on any subject that we've touched on today, as well as anything related to real estate. I'll always be glad to help you. So please give us a call if you need us. Thank you for watching. Thank you for being you. If you're taking the time to watch this, that means that you are proud of what you do, and I'm proud of you too. So thank you for sitting through this with me. I hope that you've gotten some good tips and tricks. And again, call me if you need me, 352-394-7408. And if you want a copy of those marked up contracts and writers, then ask to speak to Eliana and she'll email them to you. I look forward to speaking with you, and happy selling.